Hey everybody, thanks for coming out in the snow. I'm Thane Rosenbaum. I'm the creative director of the Forum on Life, Culture, and Society. Welcome to the FOLCS Conversation Series of the 92nd Street Y, which today is co-produced with the 92nd Street Y's Talk Series. We've been here with the 92nd Street Y for over a decade. I have moderated events at the 92nd Street Y. Are you ready for this? My buddy, Laura, you're going to faint. Nearly 30 years. Your old friend is really old. Yeah, when I first started, they didn't have lights. It was just like a campfire. But things have gotten better. They redid the whole thing. It's really nice and charged. So thanks for coming out. Tonight's conversation is law and democracy in the Trump era. You know, where in American history have we heard people use words like death of democracy, the end of democracy, destroy democracy, constitutional crisis? During the first Trump administration, during this last election, it seems like, you know, it's been a very common language. We see Senators Booker and Warren, you know, screaming, you know, in a way that we've never really seen them before. Congresspersons, there was one congressman, what is it, Hakeem Jeffries, fights in the streets describing how serious this problem is. Congressman Garcia, we might have to bring actual weapons for a bar fight. That's interesting, you know, because that to me sounds like the Oath Keepers and the Proud Boys. Like, that doesn't sound like Democrats. And so that this must be something that's really serious if people are reacting in that way. Yet, Donald Trump won the popular vote, and he has a mandate to implement policies. And the question is, should the legal system at all be involved in challenging, disrupting, interfering with his presidential priorities? J.D. Vance just recently said that the courts have no right to be obstructing or challenging what the president wants to do. He said president's Article 2 powers, and we'll talk a little about that today, about the executive powers under Article 2. He said, hey, this is what you elected him to do, and he's supposed to be an executive that runs the country. Here to discuss this extremely provocative topic, for friends and colleagues and two people who have been at FOLCS a number of times. First, the great Preet Bharara, who served 8 years as the top federal prosecutor in New York City, the Southern District of New York, which you should know, that's the most of the prestigious districts of this, you know, US Attorney's Office. Served for 8 years, widely considered perhaps the most successful one, very effective one. He's an author, best-selling author. He also infamously, when we had him last time, we pointed out, Donald Trump tried to fire him. He wanted you to resign and you said no. So he has very strong feelings in favor of President Trump. So that's Preet Bharara. We have Melissa Murray, who is a rock star law professor at NYU in constitutional law. You oftentimes see her on PBS or NPR or MSNBC. And my understanding, Melissa, you're going to use tonight as an audition tape for Breitbart.
I'm trying to expand my audience.
I know. Andrew Weissman, everybody. You know him from his award-winning podcast on MSNBC. You know him from as one of the leading legal analysts for MSNBC. He is also a former prosecutor and was one of the lead prosecutors during the Mueller investigation, and also a New York Times bestselling writer as well, Andrew Weissman. And always, last but not least, this one, my old buddy, Laura Coates, the Laura Coates. So Laura Coates has her own show live with Laura Coates at 11 p.m. tonight at 11 o'clock. So we're going to leave her. She's going to run off and do hair and makeup. But that's,
I woke up like this, excuse you.
Yeah. She looked exactly like this. And you all can actually, if you run home in the snow, you could feel like you did a double take. You could have, oh, I just saw her. Oh my God, that's her. Yes, she has this really great, charming, she's what I always call the charming show on CNN. And then why do I say the hardest working woman in entertainment business? 7 in the morning, she's up with a Sirius XM radio show, the Laura Coates radio show, from 7 till 9, is it? Or 7 till 9, I've occasionally...
That deserves a hand.
Yeah.
Not at 11 to 7.
I mean, and she's got kids, and she gets up again to do another live show. So the wonderful, she's also the chief legal analyst for CNN, Laura Coates. Now, before we get going, I know what you're thinking. I know what you're thinking. What you're thinking is, I don't see any conservatives. I don't see any Republicans. I don't see anyone from Fox. I don't see anyone from Newsmax. I just see these people, and there's a reason for that. It would be a good observation for you. New York City is no longer a sanctuary city for immigrants, but it is a sanctuary city for Democrats. This is where Democrats who are in despair can dwell, certainly here, in peace and enjoyment of their lives, free of country music. We're still not sure about congestion pricing. The congestion pricing only applies to Ford pickup trucks, my understanding. And so if you are here as a Republican and you're noticing this absence and you somehow got through security, I want you to know I'm here for you. I am, to be fair, I'm to the right of my friends, but then again, so is Mao Zedong. And Ralph Nader, who rejected this. I will play the role. I will push back. So for those people that are saying, where's that other perspective, you will somehow getting it from me. All right, so let's start with, I want to start with something that's going to be really provocative. Let's set up the, when Adolf Hitler was named chancellor in 1932, I know Andrew said, what? When he's chancellor in 1932, right, because, well, it's going to come up. Soon thereafter, there was an election. He barely squeaked by with the National Socialists. As soon as he won that election, stormtroopers swept across Germany, eliminated all political opposition, shut down opposing newspapers, literally shot people who opposed him, trade unionists, other political leaders, and you know, that's how that system started. Elizabeth Warren and Booker would have been shot by now, just to be clear. The people that are singing songs in Boston, now the Boston Tea Party is an a cappella group, it's a little different, but they would not have been able to be arrested. And that there should be at least some perspective about that. I mean, that might mean that we're not opposed to a large extent to some of these executive orders. But the real question is, in the context of separation of powers and checks and balances, what is the role of courts and Congress in a situation like this when J.D. Vance is saying, wait a minute, we want a majority of the votes, we had a mandate, we have stuff we want to do, we're just doing the stuff we want to do, why are you mucking it up? That can't possibly be democracy. Isn't democracy that we won the election? Why are you saying there's a death of democracy? We won. All right, let's go. Let's start this.
I mean, well, I have to challenge the notion of this common phrase of there's a mandate. The last time I voted, and I vote every time, I've never had because and then fill in the blank at the end of that. Or here is the directives I insist that you do. And so the assumption that somebody being elected to the presidency translates to all the marbles and the elevation above co-equal branches of government is really nonsensical. But I think when people talk about what the courts should be, it's the ought to be category. They really are the last line of defense, particularly when another co-equal branch of government, the legislative branch, is ceding authority in a way that creates a hierarchy that our founding fathers did not anticipate. And I think the courts have got to be in that role. The problem is they are impotent in some areas compared to what I think we all would like to have happen. They can only do so much before they expect for a domino effect or a trigger for the legislative branch or the executive branch. But I reject the notion that by virtue of winning the presidency, whatever party you're in, that means that you have now been elevated to a role of a king.
Well, can I just say something about that? Alexander Hamilton, by the way, they made a musical about him. No one will see it. in the Federalist Papers, I mean, I know this is going to freak you guys out, but would Alexander Hamilton have a problem with these first 100 days? Because in the Federalist Papers, I just looked and he uses the words, what we need is an energetic executive. It's an interesting term of art. Joe Biden does not look like an energetic executive. Donald Trump looks like so I'm sure you're going to hear this more. I'm sure you're going to hear people quoting what I just said. Isn't this what the Federalist Papers was arguing for? An active, commander-in-chief.
I don't need to remind you that Alexander Hamilton wasn't the only author of the Federalist Papers. There were two others.
But no one else got the musical.
No one else did get the musical. You're right. Hamilton took a more robust view of executive power, thought that the power of the executive extended beyond what was enumerated in Article 2, but he was matched with James Madison, who had a much more cabined view of the executive, and someone who believed very much in the idea that the Constitution was delineating a separation of powers in order to prevent the consolidation of government power in any single branch. And these are people who are really railing against a parliament that had subjugated them for years. And so it's not surprising that in Article 1 you have this very clear delineation of what Congress can and cannot do. Article 2 is more spare, it's more open textured. But Madison was very clear, by design, we didn't want either the Congress or the president to have too much power. And this is reiterated throughout our history. If you recall, Youngstown Sheet and Tube versus Sawyer, the famous steel seizure case.
Remember, that was Harry Truman taking over the steel factories, and the Supreme Court blocked him.
The Supreme Court blocked him, but there's a really interesting concurrence from Justice William O. Douglas that talks about the whole idea of constitutional design, and he notes that Congress is, by design, slow-moving, sclerotic, deliberative. It's a multi-member body. It moves slowly, and that's because it has so much authority. It cannot just move and use it all of the time. If it did, it would become despotic. Then you have an executive that is supposed to be more energetic, more agile, more nimble. The problem comes if that executive goes beyond the scope of his articulated powers and starts taking powers that belong to Congress or some other branch and can use them because the executive is so nimble and agile. And when Douglas is thinking about this, he's looking in the rearview mirror and he's looking at exactly the example that you opened up with. He's looking at the 1940s where energetic, charismatic, agile executives like Mussolini and Adolf Hitler consolidated power, took power from the legislature, and became despots. That's what our system of constitutional design is supposed to prevent, the consolidation of power in any single branch so we don't become a dictatorship.
So I'm going to welcome you to NYU. We both teach at, actually,
this is a faculty meeting.
This is the faculty of NYU. This may be the most interesting faculty meeting known to man. But I'm going to just quickly sort of foot stomp on the Youngstown case. There's another, sort of the famous concurrence by Justice Jackson. It's known for creating this three-part test of sort of dividing government and power and saying that
Andrew, a little closer here.
The president's power is at its lowest when the president is acting contrary to congressional authority. But the part of that concurrence that I think rings so strongly now, and remember this is written in the 50s, is Justice Jackson talking about the enormous growth that was not anticipated of the presidency, and gives a lot of reasons why, whether it has to do with the party system, the bully pulpit, just how powerful the executive has become in the constitutional framework, and rings this alarm that the court has to be incredibly careful when the president is claiming unique and preclusive authority to act, because that's the most dangerous time for a working democracy. And the background of Justice Jackson is so important to this because he came to the bench as the lead prosecutor in Nuremberg, to bring it back to your opening.
Yes, good one.
Someone who had worked as a lawyer in the executive branch, so he understood what the scope of executive power, if unchecked, would look like.
Yeah, but Melissa, he worked for a guy who eventually put him on the court, for FDR, who, are you ready for this? You're all sitting, right? 3,700 executive orders by Franklin Roosevelt. 3,700. Trump is nowhere near this. Remember, that's where the court packing problem.
That's because we're 4 weeks into it.
Yeah. No, but I'm just saying that was a lot. That seemed like an overreach. That's why the Supreme Court that's why we talk about court packing, because he was getting sick of putting executive orders out there that Congress was authorizing, and all of a sudden the Supreme Court would say it's unconstitutional, and he said, the hell with that, let's put more court judges on them. So I'm saying it's not as if this is not the first energetic executive.
But I'm glad you mentioned that historical precedent, because the language being used in the first few weeks by members of the executive branch and the Congress, who are Republicans, who are on the side of Donald Trump, about members of the judiciary are astonishing, troubling, and frightening.
Like what?
In the context, I'll get to it, in the context in which most of the judiciary has a huge number of Trump appointees from term number 1. There will be a slew of additional appointees in term number 2. The Supreme Court, unlike in the days of Franklin Roosevelt, when he was being stymied by a court that did not reflect his ideology, his politics, what he campaigned on, and largely what the country was about, you instead have a perfectly aligned court, 6 conservatives, 3 progressives, 3 of whom were personally appointed by the President of the United States, and as I said, the ranks of the district court judges and appellate court judges full of Trump appointees and other Republican appointees. And then you have a temporary ruling by a very well-considered, thoughtful judge, who I know personally, Judge Engelmeyer, while he was on call to listen to a matter while the permanent judge was not available, decides on a question of whether or not the Doge could have access to sensitive materials of the Treasury, says, you know what? At this moment, I'm finding there's potentially irreparable harm. Let's wait like 6 minutes until the regular judge can listen to the case. That's all he did. It's batshit crazy that Mike Lee, United States Senator, said that was the equivalent of a judicial coup. You have other people, like the head of the Doge and Trump and others, who are, it's one thing to say, if you're Franklin Roosevelt and you have a Supreme Court that's totally out of touch with everything you're trying to do. This is at the first level, when, by the way, you have some recourse. It's called an appeal. You have a second appeal to the very court that you have stacked with your people. So, I don't want to overreact to rhetoric, but it's kind of nuts.
But I was struck by something you said a moment ago about Roosevelt was trying to implement policies that were you said in alignment or with what the country was about. And that's exactly what Trump's people are saying. They're saying, no. Yes, it's true, our court now is more sympathetic to us than the court was to Roosevelt, thank God, they would say. But we are in alignment with what the people want, and why are you in our way?
It wasn't a unanimous win, they keep forgetting. And I think that is a crucial factor. The idea of suggesting that millions of people did not vote for Trump, and therefore their voices are silenced, I don't think, in its essence, there is anything wrong with an executive order. It is the prerogative of the president to do that. It's also the prerogative of the next president to be able to overturn and undo it. The problem is we have a constitution. I know this is a very thorny problem for people, but it's a constitution. And we are supposed to have, by more than a handshake and a wink and a nod, the notion that that which the executive or legislative branch does follows the Constitution. It's not supposed to be an election is not a carte blanche to ignore the very premise that gives the power in the first place.
What bothers the three of you more? The lack of congressional authorization, the use of money that the Congress, with the power of the purse, is not implementing, or is it the oversight from the court? Like, what is it that you're saying? Or you're saying actually all of it? We want separation of powers and checks and balances, and we want everyone to do their job, and we want them to step up right now.
I'm in the both and category. How about you guys?
Like, for instance, Doge, and people talk a lot about Doge, the creation of Doge, and Musk's expansive authority. So people are upset about that. They're saying, I didn't elect this guy. Who is this guy? He makes a car. How did he get this kind of authority all of a sudden? He never had congressional approval. He didn't go through the advice and consent of the Senate, right? Is that, you would think, a legitimate response to all the cost cutting that he's been doing? Is saying, hey, relax, buddy. You don't have congressional, you've not been confirmed by anybody. Stop.
I'm not going to, I think because we are all lawyers, you're going to hear that the thing that is most upsetting is the lawlessness. Elections have consequences. All of us could agree or disagree with various policies. That is not why, at least I'm here and I'm upset about what's going on. It has to do with not obeying the law. Whether it is the Constitution, couldn't agree more. This idea that's like, wait a second, we were elected. That's fine. That has nothing, literally nothing to do with whether something they're doing complies with the Constitution. But there's not just the Constitution. Congress passes laws, and let's just take the TikTok ban as one. That means when Congress passes something, it is binding on the executive, unless there is a challenge to say that the Congress did not have the power. And what you're seeing now is
the Supreme Court also had a decision that was overlooked then, remember?
Exactly, that said that Congress actually had the power to do this, and you have an executive branch saying, we don't care. And the latest thing that has all of us very worried is whether we're going to get to the point where you do have an ultimate decision by the Supreme Court. It would require 5 justices, so it may not happen. And this administration says, go ahead, try and enforce it. And they violate.
On which case?
Well, it can be on any case.
Any of these executive orders.
But just to be clear, we're seeing that now in the news where judges, there are 80 cases that have been filed since January 20th. There are a series of temporary restraining orders and preliminary injunctions, and the news is that those are not all being complied with. That's unreal. We've been in the Justice Department. You can disagree with a judicial order.
You're saying there's choices. Stop. That's what an injunction means. Stop.
These are your choices. You have to comply, and if you disagree with it, you appeal it. Those are your choices. This is what you can't do. Ignore it.
And it's not even like they haven't gotten to the point where they're ignoring the orders of the court, but they are doing things, as Preet said, where they're essentially disclaiming the authority of judges. Like Paul Engelmeyer offered a very modest and appropriate order, and they basically are now calling for his impeachment. They've threatened to shut off the electricity in courthouses under the authority of GSA. I mean, it could not be more petty in addition to the lawlessness. And so the idea here is to literally use every lever at the disposal of the executive to bring every other branch to heel.
So you're saying that again, we're going back to Hitler, what he literally created enabling legislation that made him a dictator. So you're saying, we don't have that, but we have something else.
The bar is in hell, if that's what we're talking about.
No, but I'm just saying, we don't have that, but we have something else where we're simply ignoring the law and ignoring the decisions of courts to slow this thing down, to do the very thing that both of you said. That we're supposed to be more deliberate in how these things take place, and instead we're saying, oh, the hell with it, let's just keep moving.
If you get enough people in the public to reject the idea of co-equal branches of government and reject the idea of Marbury versus Madison and the supremacy of the Supreme Court and their jurisdiction to decide what the law is and interpret the law, then you can do whatever you want in this country. And the concern, so you have to be careful.
How would that even work? I'm just curious. That's an interesting point, right? How would it
but
work?
You want to be careful not to overreact to rhetoric. But in this language that I've heard about Paul Engelmeyer and it being a coup, when it's so mild, I mean, it's really nothing. And by the way, Judge Vargas, also an alum of the Southern District of New York, 5 minutes later, she continued the TRO, but she narrowed it considerably in various ways. And it may very well go the president's way. But if you're trying to lay the foundation for the illegitimacy of courts and particular judges and judges at large generally, and something that's so mild, that makes it easier. 6 months from now, a year from now, when this hypothetical that Andrew presents.
You mean the one before the Supreme Court where you
Yeah,
get five?
because the court doesn't have an army, right? The court doesn't have an army. And all it takes is a feeling and a belief and an understanding and a prediction that we can defy this one ruling by the way, by the court that I appointed a third of. And we can defy that. And what's going to happen? Is anyone going to take to the streets? No. We've already demystified them and denigrated them sufficiently that they think not only the election in 2020 was rigged, but the court is rigged even though I appointed most of them. That's what I'm worried about.
Donald,
I was saying that we've been here before in the sense of Andrew Jackson, right? When there was a case that came before about whether you could remove members of the Cherokee Nation, Georgia was fighting this proposition. The Supreme Court ruled quite clearly. And Jackson said, okay, Supreme Court, you have issued your ruling, now try to enforce it. And it led to, of course, the Indian Removal Act,
the Trail of Tears, right?
And it, to your point, you and what army is going to stop me? But the idea of allowing, this is why I agree with the lawlessness, but I also have a frustration. I was interviewing a senator the other day who, and I'll paraphrase his statements, why he did not have an issue with Doge or Elon Musk or any special government employee or any non-elected official doing what they did. He said, well, we weren't able to find the ways. We didn't have the same access. We weren't granted the same transparency. So at least someone's doing it. What's wrong with that? And I thought, well, because 435 of you and then an additional 100 are going to be rendered obsolete, and that was exactly not what the mandate is by every election. And don't you have a problem with the idea that somebody else can say, well, you're not doing good enough, and so forget the representation of the power of the people, I'll just do it, and you'll say, all right, well, at least it'll get done. That's the kind of ceding of authority as if it's an option. I mean, it wasn't like you had the actual article of the Constitution that said, if you feel like it, you can have these powers. It was, that is the power you hold, you possess, it's not voluntary, and you can't cede it. And so that combination to me is very scary, just how quickly people seem to go, well, if the ends can justify the means, I'm okay with it.
All right, let me slow this down. Let's go back to the prior Trump administration, just to remember things. The Muslim travel ban was an executive order that was upheld by the Supreme Court. The building of the wall.
The ultimate version.
The ultimate version.
Not the first version.
Right, okay, not the first.
3 versions,
okay.
Each one successively cleansed of its racism.
All right, but the building of the wall was invalidated by the Supreme Court, right? This was during the Trump administration. Andrew, when you say, I'm just waiting for that 1-5-4 decision, are you so sure that that 1-5-4 will just be a roller coaster of additional 5-4s or the completely abandonment of even worrying about those cases, because now you have an administration that's just out of control, implementing, enforcing its own power, going all Andrew Jackson, you know, and saying, let's just see how it goes. Let me just, before we get the answer, just to remember about these executive orders. Andrew, I don't think, was convinced of this. I think he was waiting for Melissa to pounce all over me. The Emancipation Proclamation is an executive order. Oh, she likes that. All right, no, I didn't. I thought you would disagree. Yeah, we've you know, I mean, everyone, it's like, that's the really great one. Obama, the DACA, the Dreamers Act, is an executive order. So just to be clear, you know, executive orders, presidential directives by definition are not terrible, but let's just get to some that might be considered terrible. The pardoning of the January 6 rioters. That is, right, no-brainer, right? Horrifying.
I think I'm going to stop you here.
Good. Hey, I'm here for that one guy that got in, all right? Just don't hate the messenger.
No, so I don't have anything to say about the January 6 pardoners because the president's power to pardon is vast and absolute, and I don't agree with it. I don't think those are appropriate people to pardon, but I recognize that his authority to do so exists. DACA is also, I think, within the scope of the president's authority, as the Supreme Court has noted. President Obama, through The Immigration and Nationality Act has a directive from Congress to be able to do certain things with regard to immigration policy, and he did through that executive order. When it was later challenged at the Supreme Court did not declare DACA invalid in terms of substance. It said that the Trump administration's efforts to roll back DACA did not adhere to the Administrative Procedures Act. So it's a procedural question. So the president can do things. No one is saying the president cannot do things, but the scope of the president's authority to act is not absolute and unfettered. And it doesn't say anywhere in the Constitution that a South African automaker can come in and access the payment systems of the entire nation with 19-year-old Doge bros named Big Balls who just want to take all of our information and put it on the dark web or whatever it is they're talking about. The whole idea that the senator was mentioning that now we have the transparency that we lacked, if we lacked it, the group to have done it was Congress. 435 people in the House and 100 people in the Senate could have passed legislation for increased transparency. To be clear, there is already a great deal of transparency because of congressional actions taken after Watergate that demand that government agencies publish and document how they spend taxpayer money. So this idea that we have been foraging around in this morass of a lack of transparency is absolutely ludicrous and is merely a pretext for what is basically a push of the United States.
Before we, I forgot to mention something at the very beginning. I know Ellie Fox from the Y is saying, what did you forget that for? There are ushers walking around to pick up questions for, if you have. So you'll see them walking around. That's what they're looking for. I know you took the card and the pencil, and so that, I should have mentioned that earlier. They'll come through again. All right, go ahead, sorry.
So I was going to raise sort of a second issue that you're addressing, because we're really talking about this idea of disobeying the Constitution, disobeying congressional statutes, and why isn't Congress pushing back? And it's not about just issuing an executive order. That in and of itself is not the issue. But one of the things that we're seeing, and the presidential immunity decision is a perfect example of that, is the Supreme Court basically hollowing out our democracy. And nobody anticipated that that decision was going to come out that way. Not even Donald Trump's own lawyers, who actually conceded some of those issues and then got more from the Supreme Court than they even had the temerity to ask for. It was just unbelievably shocking. And just to take it back to our comments about Youngstown, the Chief Justice, who wrote the majority, kept on citing it in a way that was beyond disrespectful, because it absolutely was the antithesis of what Justice Jackson had been writing about. And it is going to be, for this president, it is going to be the gift that keeps on giving.
You're saying this really all started with that, in your view, that the precursor to what we may ultimately see in these court challenges, some of which may make it to the Supreme Court, we already got our answer over the summer.
It gave the gun, and it was a loaded one. And all of the challenges in terms of the president now saying, for instance, essentially civil service rules are unconstitutional. We're going to see challenges from the executive on that, on whether Congress has actual oversight responsibilities, where the executive is going to say that is preclusive and exclusive to me, because it is within the scope that was defined incredibly expansively by the majority. And so that is something that it's going to have something that scholars have talked about, which is it's going to have the veneer of democracy, where you're going to be thinking, oh, the Supreme Court has now ruled, but it is anything but, because it's so antithetical to how the framers were trying to have sort of checks and balances, because it is really just saying the executive has all of the authority.
What about just interpreting the Constitution itself, like birthright citizenship?
What about it?
Well, okay. Is that even a question in your mind?
No, it is not a question. If you want to know more about this non-question, please tune in to the next episode of Strict Scrutiny, where we have an actual historian who is going to talk.
We have an, I'm sorry, we have a what?
An actual historian, not one of these armchair fake historians that the originalists like to trot out, who's talking about the historical context in which the 14th Amendment was ratified and drafted. It says very clearly in the first section of the 14th Amendment that anyone born in the United States and subject to the jurisdiction thereof is a citizen of the United States and the state in which they reside. And that is unequivocal. This idea that has been touted by some male law professors from other schools, not NYU, that somehow because of the protection and allegiance and some compact that we have with each other, those who are here in the United States unlawfully, their children cannot be eligible for birthright citizen. That completely defies not only the history of the 14th Amendment, but the common law history of the United States, where citizenship did not depend on your lineage. Blood, it didn't depend on blood, it depended on soil, where you were when you were born.
Yeah, but
Just say one thing that the Trump administration's arguing is that that you should strip citizenship even from women who have children here, and the women are here legally.
Temporarily, like
Exactly.
student visas.
If you're a
This is the
student
Kamala
visa,
Harris.
right.
By the way,
law.
even
Also,
very
you should have.
conservative courts have found this. I mean, the same notion, going back, thinking about the Dred Scott decision, thinking about the very premise of why we have that. But I want to go back quickly to something that Preet mentioned, and I think it's a prudent one. And the idea you said to be cautious about responding just to rhetoric. One of, I think, you mentioned the loaded gun. One of the tipped bullets, I think, has been this idea of operating and constantly being reactive with your hair on fire throughout the entire pendency of any administration. And I don't think that we have that here, but I do think that that is going to be, as much as the hurdles presented by the conflation of different veneers of democracy, the idea of thinking about, well, that's not really what's going on, did that justice say that? It's going to be also about this notion that, well, maybe women are accustomed to this, the idea of being hysterical all the time, right? The way of trying to discount what you're saying and feeling and putting you in a category, in a box, that hysterical notion, I think, is being a label that's imposed on people who are of sound mind and judgment, looking at this through the eyes of objective legal judgment. And that's going to be a huge hurdle in this second administration, as it is, frankly, throughout other administrations, but this one in particular, to try to figure out how you can convey the information in a way that is not consistently discounted by this notion that everything is Trump derangement syndrome, as opposed to, actually, I just read you the 14th Amendment, precisely. That's one of the challenges.
now,
Can I say
yeah.
that, we as lawyers and as commentators and panelists, and we're always talking about the ultimate legal success of a gambit. And I agree with Melissa and the others who think at the end of the day that the court is not going to go along with this interpretation of the 14th Amendment and will uphold birthright citizenship.
Wait, you do think that?
No, I agree with what Melissa said.
Okay.
I always do.
I
Very
didn't actually
smart.
say that.
I'm
I didn't. Well, I think there is no, like, they have no other choice. I don't know if that's what they'll do, but I
Okay,
don't.
no,
I
that's
agree with your
important because
analysis,
that wasn't
and
clear.
I'm optimistic about what will happen. But the point is, even on things on which they will fail, they have already a little bit won, right? On the birthright citizenship, if your point is to cause uncertainty in the minds and hearts of people who are thinking about coming to the country, well, I don't know how this, like, I'm not Melissa Murray. I don't know how it's going to, and even Melissa Murray doesn't know how it's going to turn out, even though she thinks correctly that it would be insane and ludicrous for it to come out the other way. So they've already won a little bit. When they decide,
Because no one ever considered that it didn't mean
well,
being born here meant
because this is an administration that believes in the chilling effect of their actions, whether their actions are meritorious ultimately or they're complete insane whack-a-mole bullshit. Another example of that I find to be terrifying is this idea that we're gonna submit questionnaires to all the FBI agents who may have in any way, shape, or form, even remotely, touched the investigations of the January 6th defendants. Ultimately, they may fire, they may not fire, they may be challenged under the civil service laws, whatever happens to those. The fact that they issued those questionnaires, to me, has such a chilling effect on future FBI agents who are thinking, do I pursue this lead that's been assigned to me from headquarters? Do I have to think to myself, well, is the target of this lead someone who in some way is connected to the president or connected to Elon Musk or connected to Don Jr.? And if so, will someone rip my livelihood away from me because I did some surveillance or I served a subpoena? So even if ultimately these things don't succeed, it's not enough to cause them to fail ultimately. They have to be fought at the root.
Even forget a questionnaire. How about I'm going to dangle a case above you, Mayor, in the event, and I'll do it dismissed without prejudice, meaning that we'll see how it goes. And if I think that you have done what I expect to happen in terms of following out the policies of a president in an individual city, then you might be safe. I mean, if a questionnaire to an FBI agent about what did you work on is enough to make you hurl, then imagine the idea of, well, I think you're too busy, right, doing the work that we talked about for immigration purposes. You can't possibly be bothered with a case or an indictment. That's not a quid pro quo. I'm just saying, right, you couldn't possibly have the time to do the things I told you to do and we talked about for the idea of immigration if you've got an indictment. But that's the, I mean, if the questionnaire is too much, then what is that dictate?
But they're not even hiding that. Like they saying,
say it's not. First of all, they say it's not a quid pro quo. He is.
I know, but they're
talking
also
about Mary Adams, right? We're all on the same page.
Yeah.
But
No, I just want to be clear. We're talking about
clear.
right. Yeah, we're talking about Mayor.
They say it's not a quid pro quo. That there was never an agreement. He stood up in court and said this is not the case. But the intimation is what is sometimes enough for people to lose confidence in your credibility.
So we have all of you have been prosecutors at some point. Melissa also as well?
No.
No. He was once the top prosecutor. Mueller, you've been a prosecutor.
I've only been married to a prosecutor,
Right.
so it's all very attenuated.
Trump is saying, I am not saying that I think the case is weak. I am not saying that it's insufficient evidence. I'm saying is I need that guy in that job because it's a blue city with a lot of illegal immigrants, and I have a mandate to do something about it. And I got one player. I don't got one in San Francisco. I don't got one in LA. No major city do I have a player. I got one player, and he looks good in a suit. I want him to stay in office. That's what I want. I'm not talking about what the law says. I just want him in office. So I'm just saying, you may be right about it. It's not a quid pro quo, but it's actually remarkable how openly they're saying, this isn't about the legal system. This is simply about, I need him in that job.
So it's important to focus on what Laura said. The case was not, they did not move to dismiss the case with prejudice. They did not pardon the mayor, which the president has the power to do that. They put him on a choke chain. And they, as you correctly noted, were explicit that this is to make sure that the mayor can conduct policies that are consistent with the Trump administration's immigration policy. We then saw the mayor go on TV and announce that ICE agents were going to be allowed into places in this city, such as Rikers, to effectuate federal policy. Just to be clear, that is against local law. So you have a mayor who is under indictment still for 5 felonies. He is out on bail and is saying, I am violating local law. You also have Emile Beauvais, the acting deputy attorney general, who went into court and said, even if it was a quid pro quo, this is like, I totally agree with what you said, and the second part was, even if we're allowed to do it. So you have right now the number 2 in the Justice Department saying that the criminal law can be used as the sword of Damocles to effectuate policy. I mean, that is, if you want to think about undermining the rule of law in this country, it is incredible that somebody from an esteemed office, who was a federal prosecutor, would think that that is an appropriate use of the criminal law to effectuate policy. Imagine if what he said was, you know what, you're a member of Congress, you're a Democrat, this is what we're going to do. The quid pro quo is that you're going to vote with the Republicans. And if you don't, we still have this case in abeyance. It is no different.
It's also profoundly anti-democratic for the people of New York who voted for an elected leader to represent their interests. Last week, the federal government took back funds that had been appropriated by Congress to the city of New York for housing migrants in this city, and they just took it back. Ordinarily, you would expect someone like the mayor of New York City to make a stink about that, to say something about it. But this mayor cannot say anything because this mayor is on a choke chain, as Andrew notes. He's not going to say anything, and that means he's probably not in a position to represent the people of New York and to act in our best interests because he's acting in his own.
So, here's somebody who people are worried that is on a choke chain, and she actually has a name, Chutkan's, so it fits nicely. This comes, I forgot to mention, we have a large audience here today, but we have a really large audience watching on virtually. So this question comes up here right now, fits in right nicely where you were, Melissa. Please explain Judge Chutkan's decision not to prohibit firing of federal employees in the complaint. This is just from 2 days ago. 14 state attorneys general, which actually raises another question. Do they even have legal standing to make that claim? But okay, I just want to say that's where the case was. 14 state attorneys general brought that case, and she ultimately said, explain that.
Well, to be clear, it is a very limited ruling. The case came to Judge Chutkan, and she basically said that the states who had asked for a temporary restraining or preliminary injunction, temporary relief, may not have had standing because they couldn't establish irreparable harm. And the big reason why they couldn't establish that they would be irreparably harmed by DOJ's use of the payment systems or their infiltration of the payment systems is because they didn't actually know what Elon Musk and the Doge bros, big balls, et cetera, were actually doing with the information.
But wasn't this case about the firing of an agency head?
There are a bunch of different, the case that you're referring to that Judge Chutkan just issued this order for is the case regarding the infiltration of the payment systems.
Right, which is separate, right.
It's a different case.
But remember, just to be clear, Judge Chutkan sentenced most of the January 6th rioters. She had many of them.
Well, there were other judges like Amy Berman Jackson.
She had the original federal case in the overturning of the presidential election.
But she's following the law, and the law requires for a preliminary injunction for the claimant to show irreparable harm. And in this case, the states could not show at this moment that they would be irreparably harmed because nobody knows what Elon Musk is going to do with that information. And Judge Chutkan in her order was very clear about that. She said that on the merits, it could be the case that the states have a very good claim. And to be very clear, she read Elon Musk and Doge, which is a fake department, for filth in her order. But she said, right now, in this moment, when I'm being asked to issue this preliminary injunction, I can't because I don't actually know what the irreparable harm is, and neither do the states. So come back to me in 2 weeks when everyone's information is on the dark web.
Which, of course, incentivizes the lack of transparency.
Yes.
If you cannot rule in a way because you don't know what I'm doing, why would I make it apparent what I'm doing?
So one of the things in the law that's probably pretty shocking to non-lawyers is this, for irreparable harm, there is a body of law out there that just being fired is not irreparable harm. Now, there are nuances to that, but this is a judge, it's a perfect example of a judge trying to just follow the law and not following her own sort of personal views.
She's not saying, yeah, I know you're fired, but it doesn't constitute irreparable harm.
Right, so this is one where it's really stay tuned because the court was absolutely clear that on the merits they were likely to win, and as soon as there is actually more that happens, she didn't say don't come back. She's like, come back when it's riper.
This question is not really necessarily a question, but I think it's something I neglected to mention earlier, and I always feel to tell you, you come to a FOLCS conversation, you always walk away smarter. And the one thing I wanted to tell everyone is there is something, a theory, called the unitary executive theory. And that is a term of art that I guess law students hear about very early on. But this person is asking, is a unitary executive the goal, right? She's asking, he or she from the audience asking this question. And I think the argument is that's what Donald Trump would want you to believe, that the idea is that there's a maximum amount of power that Article 2 grants the executive, and that it is a power that he or she only possesses. And to a large extent, although there are 3 branches of government, there's this one that's not the king, but it's a little closer to the king than the other 2.
But I think what you're hearing from us is that it's not a question of the unitary executive theory, and there are lots of sort of issues with that, but it's a unitary government theory. That is what is going on, is the idea is that you delegitimize the other branches, and you also you make them cower with fear. You have a US attorney in DC sending letters to the Congress saying, essentially, I have my eyes on you and I want to open a criminal investigation based on what you're doing. You talk about Paul Engelmeyer in these incredibly disparaging ways and with public threats. That is not a unitary executive. That is to say there should be a unitary government, and that is contrary to what the Constitution provides.
You have something to read, and I want you to read it. We mentioned briefly the Eric Adams. It was funny how Laura said, you do know we're talking about the mayor. It's like, this is the 92nd Street Y. We know this stuff.
I was bringing the Captain Obvious vibe.
Yes, no, it was very sweet. Like, let's just remember what we're talking in hushed tones. Preet, although, you know, former U.S. Attorney, Southern District of New York, who you'd think he'd want to weigh in here, can't. He can't because he works for a law firm that used to represent the mayor, no longer does. So he.
I don't know that no longer does, but we used to represent the mayor.
Right. So he has a conflict of interest. So we even debated whether we can even talk about it at all, and we talked about it briefly. But then Preet actually showed up with a document that he wants to read and wanted.
You know, there are all these proclamations. We're talking about the executive orders issued by the president, but everyone has their own version of that kind of document. And Pam Bondi, who was just recently confirmed as Attorney General, also on day 1, everyone's big on day 1, issued a number of directives and memos, some of which got more attention than others, and one of which didn't get as much attention as I think it kind of deserved, because it's kind of rhetorical. It doesn't say anything specific about policy, but I think it's very jarring in a couple of respects. The first sentence of it's called the General Policy Regarding Zealous Advocacy on Behalf of the United States. The first sentence is unobjectionable. It is the job of an attorney privileged to serve in the Department of Justice to zealously defend the interests of the United States. Nothing to get upset about there. The second sentence, relating to what we were just talking about, those interests and the overall policy of the United States are set by the nation's chief executive, who is vested by the Constitution with all executive power. So it's sort of getting at that issue a little bit. But then a couple other sentences that I found kind of astounding include this one. The discretion afforded department attorneys entrusted with those responsibilities does not include latitude to substitute personal political views or judgments for those that prevailed in the election. So, by the way,
what does that mean?
It's 3 paragraphs. It makes a reference to the election. There's no reference to the Constitution in here. Even the most sort of unmoored person from the law, when they talk about what their responsibilities are, will say, I have X power, I have Y power, consistent with the Constitution, or consistent with the laws.
In fact, the term of art is constitutional authority.
Yeah. This mentions those that prevailed in the election, does not mention the Constitution. It also talks about how anybody who refuses to advance good faith arguments on behalf of the administration or otherwise delays or impedes the department's mission will be subject to discipline and potentially termination. So again, alone and without all sorts of other things that we see going on, the questionnaires to the FBI agents, the mass firings and everything else, but in the context of everything else, I think this is a very dangerous document.
Well, can I ask a question?
Yeah.
Are you reading that in the original German?
Da.
So you think that's the enabling legislation I was talking about earlier. You think that's what that is.
But
all right, let me.
Part of it, by the way, there's no hiding anything, right?
Well, that's what I said before.
You could
about
do
what
all
they-
of this. You don't need this document. There's no hiding.
Yeah, that's what I said about what they were saying about dropping the Adams case. They're saying we're not even talking about this as a legal matter. Let me ask a tricky question. For all 4 of you, is there any of the executive orders that you like?
I hate paper straws.
So you thought that was a good one.
That was a great one.
You applaud that one.
There you go.
All right, we got one. Is there anything else that we could reach? Can we even moderately like that we can understand? We don't agree with it, but we understand it, and we don't think it has any constitutional problems associated with it.
Well,
besides paper straws.
Well, there are a whole series of things that Pam Bondi did that fall into the category of elections have consequences that I disagree with, because I think that they're really bad for white-collar crime being prosecuted. It's, as a friend of mine who's a white-collar defense lawyer said, this is the perfect time to be a white-collar criminal. The FCPA, Foreign Corrupt Practices Act, is now not going to be enforced except for drug cartels, which drug cartels don't violate the Foreign Corrupt Practices Act. So that's like saying we're going to enforce tax laws on the destitute. The election interference prosecutors, whether it's in what's called the kleptocracy unit, whether it's in the actual election interference unit, all of that's been disbanded. CISA has been disbanded which deals with election interference here and election integrity here in the United States. All of that is something that Pam Bondi has the authority to do. That is legal, but in my view, a terrible, terrible policy judgment, and tells you a lot. But we'd be having a very different discussion.
Mexican drug cartels being labeled, designated foreign terrorists? Not even that one. Don't love that.
I think having been in the intelligence community, I think it is very dangerous to go down that road of starting to target groups as being terrorist groups. And I can see that not being just applied in a foreign context. And there's specific congressional definitions for what it means to be a terrorist group. And so I don't think you can still, going after them, absolutely. But the label is dangerous.
Yeah, but I'm sure Pam Bondi, if she were here, she'd go, you may think it's dangerous, but it really makes it a lot easier for us to go after them this way. And that's why we're doing it, Andrew.
It has zero effect.
So you're saying it won't help them?
Zero. The question, whether you put that label on them, will have nothing to do about whether you have good prosecutors and agents doing this. And one way to do that is if you're not getting rid of prosecutors and agents at the same time that you're saying you really want to enforce the law.
But on the list of evils
Yeah.
that we're spending time on, relatively low.
Totally.
Okay.
Okay, good. All right. Fentanyl from China. There seems to be one associated with that. I'm not sure exactly what it says, but he obviously is saying, stop doing that. Right?
That's great.
You like that one?
So this is what's so, like,
Well,
okay, so
saying,
Ann Milgram, who is the head of the DEA under the Biden administration, had that as her preeminent mission, was dealing with that. So I think that is also, to Preet's comment, it's not like the worst thing in the world to put that out there. It wouldn't be the only time that any administration has put out some sort of directive as a sort of publicity point to say we care about this. But as a substantive matter, the issue is, what are you going to do about it? Can you top what Ann Milgram has been doing in the DEA? That's all I would care about. Whether you issue a directive or not doesn't make it one difference.
But part of the problem is that Trump's very politically smart. And some of the things that he wants to do, the headline, the bumper sticker, is fine. We don't want fentanyl from China. Who wants fentanyl from China? Anyone? I don't. Who wants bloated government that doesn't do anything but waste, fraud, and abuse? The Doge, in principle, is fantastic, right? And you go through thing after thing after thing, other than Putin is great. That on its face is just ridiculous. But the problem is, a lot of his supporters and other people, they see the bumper sticker, and that's enough for them. And then people like us say, well, the way you go about doing it matters too, right? So you can say you're against crime, and that's wonderful. We have an anti-crime initiative, but if the idea of your anti-crime initiative is no due process, and Gestapo tactics, well, that's terrible. You have to speak up against that. But you're up against, I think, a political, rhetorical wall when you have lots and lots of people who I believe in many ways resemble cultish behavior, say, as long as we like the principle of it, the bumper sticker aspect of it, however you want to do it is fine with us, and it's not fine.
This is, don't forget, it's we've been, for years, it used to be the Y, and it's N92Y, now it's 92NY, but it really is the YMHA. It's Young Men Hebrews Association. So you can't ignore one of the executive orders that is specifically to combat anti-Semitism, and to do it in a much more directed way, adopting the IRA definition. Anyone have any strong feelings about that? For some people, adopting the IRA definition itself is a problem, right? But this seems to be saying university campuses, federal offices, the country itself didn't respond to anti-Semitism appropriately in the aftermath of the October 7th war, and the federal government's going to step in with an executive order to be very direct and specific. In this room of all stages, what do you think? We like this one? You don't like
My show starts in about 2 hours. I gotta head out right now, real quick. It
I
starts
want
at
you to know
11
this
o'clock.
woman
Sorry, I gotta
is
go.
gorgeous.
I'll let you,
She's going to leave soon anyway. and she's going, look, I don't want this to upset my
Well,
makeup.
no, I told you I wouldn't wear makeup. Fundamentally, I think it goes back to the point that Preet was raising, and frankly, all that we've been talking about, and that is, full stop, President Trump will do actions that you will agree with. There will be things that you think are fundamentally sound. The devil will be in the details, and if you're willing to put blinders on and ignore details, if that does not matter, and you would just like the ends justify the means, well then there is an entire Capitol Hill that would be directed at that. But if you're talking about enforcing people to conform to behavior that the government believes is the only appropriate type of speech to use, then you're going to have to take that First Amendment and throw it out the window on your way to Washington, D.C. And to the extent that today you might agree with an objective or agree with a sentiment and want that conformed belief to be what's heralded everywhere, just know that at some point, the speech that you don't agree with, or the one that you might have that someone does not agree with, is going to be on that next chopping block. Now, you're going to have to take that good with the bad if you believe in the Constitution and the First Amendment. I happen to believe in that. I happen to believe that I don't want the government deciding what my thoughts should be and dictating it, or telling me what I cannot say, as long as it's in line with the Constitution. And I think for any topic, no matter how cavalier or egregious, that is the fundamental core of a democracy. And you have to choose what type of life and world you want to be in. And if you're offended by the fact that sometimes somebody will have the audacity to offend you, you're not going to go very far in understanding what I thought America is striving to be.
Good answer.
I noticed none of you wanted to take the heat.
No, I
Y'all
thought
work
that
at
was a very,
university.
can I just say, I think that was a very wise and brave answer in a very complicated subject, to take a pure, the essence of our democracy is the First Amendment. And everyone takes that, they always say it. A year ago, remember we were doing this a year ago, I think a year ago we were talking specifically about this.
Yes.
So.
And some of the threats have been realized that we talked about.
Yes. Before we send Laura and all of our guests home and back to a studio, let me take this one. This should be our last question, because it's an interesting one. While the judiciary has a clearer role in domestic affairs, to what extent can you restrain the president in foreign policy? I.e., are we pretty clearly on target for World War III?
That's the easy end question?
Yeah.
Good
I
news.
thought that was just end on a flourish. I want us to leave on a hopeful note. No, it's not World War III. Go home.
Well, the Constitution does, in many ways, give the president a lot of discretion in foreign policy.
As commander-in-chief.
As right, but in foreign policy.
Right.
But it also gives a lot of power to Congress. And it's obviously the power of the purse, treaties. I mean, there's a number of enumerated powers that belong to Congress. So if you go back to start with, you go back to Youngstown, that is an area where there is joint authority. It is not something where the president should be able to say that this is exclusive and preclusive to me, although historically it has been true in Democratic and Republican administrations that the executive has, to paraphrase Justice Jackson, really grown in influence where Congress has receded. And in many ways, it's because Congress realizes there's not a lot of political gain to weigh in and lets the president take that.
So Andrew, you're saying, so like, for instance, the war on terror is a good example of something that seemed to be run out of the White House without a lot of challenge from the legislative branch.
At different times. I mean, when it first happened, the Congress did get involved more, but with a vote that many really people regretted having to make a decision, and not a lot of people domestically will vote on foreign policy. You see that receding. But just to be clear, that is an area where if you were going just by the Constitution, there is joint authority.
So can I resist the premise of the question a little bit? It feels excessively formalistic and categorical, and it may have made sense, I think, in 1938, for example, when the court decided the Curtis Wright case, which is the analog to Youngstown. Youngstown is about the president's domestic power, which is more limited, and Curtis Wright is about a more expansive vision of the president on the world stage. But a lot of our foreign endeavors have really profound domestic implications. So to make this sort of clear division between what the president can do in foreign affairs and what the president can do in domestic affairs is really a distinction without difference these days. So if the president is making policy that impacts oil-producing countries around the world, that will be felt domestically. So, if we're talking about the president having this wide range in foreign affairs, that will mean in time that the president, especially one with a very muscular vision of presidential authority, is going to import some of that authority from the foreign stage into the domestic sphere.
You're saying it's never a clear field for him.
It's never a clear field for him, and if we concede that it is broad and basically unfettered, in time, there is going to be an effort to import that broad expanse of authority on the world stage into the domestic sphere.
A great way to end. Keep in touch with the 92nd Street Wise Talk series, where we're always open for business. FOLCS.org for our programming. We're always here, but we're also at other locations. Want to thank, this was really fun, interesting, exciting, illuminating, just awesome. Preet Bharara, Melissa Murray, Andrew Weissman, and the great Laura Coates.
Thane Rosenbaum.
Good night. You're so awesome. I love you.
Great. Thank you so much.